We're back with all of our parties and attorneys. We did have Mr. Turnus call in. So we informed him of the adjournment on the pretrial and the proceedings for him, but also Ms. Thomas indicated she'd like to call him as a witness. But rightfully so, we wanted to get a hold of his attorney, Mr. Brooks, so that he can be here for any witness testimony as well. So we have a POL on Mr. Brooks, and we'll call Mr. Turnus back. We get a phone number for him in the event that we can get that lined up. And then, of course, Mr. McFarland's client was on the stand. Are there any more questions for her from any of our attorneys?
No, Your Honor.
I do.
Okay, all right. You remain under oath? Yes, come on out to our witness stand.
We took a lunch break. You advised me that you wanted to address the court if you're going to have a relationship with the father of these children or not, correct?
Correct.
What is your position that you want to tell the court?
I don't want any relationship.
All right, can you speak up? We got Ben right here.
Sorry, I don't want any relationship with them.
So he would not be involved, you're saying, in as far as you raising the children?
I don't want to fight for custody. Full custody.
What's your thought process behind that?
On why I want to do it?
Yes.
I don't think he's fit to be in our lives. I don't.
You mind to elaborate? Is there something that you think he may have done that raises this?
The way he treats his other kids and how they grew up, as well as not just what I'm going through.
Have we covered anything additional that you want to add? Or is there anything else?
Not that I can remember.
Okay, we'll see if any other attorneys have further questions.
Questions based on those questions?
No, Your Honor, thank you. No, thank you.
Thank you for your testimony. May you return to your seat. Any other witnesses today, Ms. Thomas?
Your Honor, I'll call Ms. Miles. Thank you, Ms. Miles. Where are you currently employed?
Currently, I work for MDHHS as a CPS investigator, now under Washtenaw County, but during this case, I was working through Lenawee County as a CPS investigator.
Thank you. And you are the one who signed the petition as relates to the older two children, is that correct?
Yes.
And just to clarify for the record, you did not sign the petition as relates to the youngest child, correct?
I did not.
But as the ongoing investigator, was the youngest child considered part of your caseload?
Yes. So the on-call worker, Ms. Caitlin, she handled the petition, everything that happened over the weekend. And being that one, she's not a CPS investigator technically, she's foster care, and I have the most knowledge of the family. They assigned that case to me the following Monday after everything had transpired over the weekend.
And as the investigator in that case, did you have the opportunity to review Ms. Caitlin Young's case contact notes and the medical records as it relates to the youngest child?
Yes.
And at that point, did you agree with Ms. Young's allegations that were contained in the petition?
Yes.
Okay. Now we're gonna rewind a little bit. Okay, back to May. In May, you received a case involving this family. Is that fair to say?
Yes.
When you received the complaint, what, to the best of your recollection, understanding, what were the primary concerns surrounding this family?
So the complaint initially came in with a maltreatment of physical injury, which on-call went out because it came in on a Sunday, and there was bruising that was due to the oldest child's forehead. Again, on-call went out and made that original contact where the family indicated that bruising had came from both of the minor children kind of fighting with each other, and they denied any, I guess, physical abuse or injury being the reason or cause of those bruises.
Did you have any concerns about the bruising at that time? I know you weren't the direct worker, but when you reviewed the records and I believe photos were taken at that time?
Yes, so with any type of bruising that shows up on children while working with them, that's usually always a concern. I didn't necessarily believe that these two children may have caused this bruising, but that's what the parents said. That's what I had to go from. I then still followed through and made contact with the parents myself a few days later after the on-call worker had went out. At that time, the story for the bruising had changed. It went from originally the children fighting each other, causing the bruising, to now when the children play in the home, and they have socks in the hardwood floors, they slip on things and sometimes hit, their body parts on what might be a cabinet or other objects.
Okay. I want to kind of backtrack because there's been some testimony that around the time that Lotus Child was turning 2, the parents provided a delegation of parental rights to the maternal, I think during testimony, it was reported maternal aunt, but I believe it's the maternal grandmother, correct?
Yes, the power of attorney was under Crystal Rosas, which is maternal grandmother.
And during your investigation, back in the beginning of May, was the maternal grandmother still the agent? Meaning, was that power of attorney still active?
It was still active, but the children were not residing with grandma full-time. They were with mom and dad.
Do you know why?
Why there was still a power of attorney?
Or why they were not residing with the agent, the maternal grandmother anymore?
So mom and dad, under a power of attorney, of course, have the right to take their children back if that's what they would please. But there were also concerns around maternal grandmother was not allowing the parents to see the children while she was caring for them, which upset Angel. I didn't have the direct conversation with Jarrell, but I would assume that probably upset him as well.
Okay.
Objection, Your Honor. I guess, well, that'd be hearsay. I realize hearsay can come in, but his attorney is not here, Mr. Jarrell. So I have some concerns with us taking testimony regarding an individual who's not represented and is present for this hearing. I think he's still on Zoom. So when he has counsel.
He's not on Zoom.
Oh, I did not realize.
Well, Your Honor, I can understand that concern. Admittedly, yes, that statement would be hearsay. I can move on from it. I believe the court will take it for what it's worth. Point out the fact that there was testimony made by his client just now regarding the same individual.
Also, is this a statement from Jarrell? Is that what you said?
So mom had told me directly that she, grandmother did not allow her to see the child. I never had a direct conversation with Jarrell. Just being that those were his children, I can't figure that he would be too happy about not being able to see them either. So.
Okay. Okay. All right. Yes, I can see that that's hearsay from the grandmother, but it's also from your client. So, that's because we had.
I also see speculation, Your Honor. She said, I presume that this is what his feelings would be. And
I'm not too concerned about the bit about Jarrell. He's already pled.
okay.
And if that becomes an issue, then so be it. But he's already admitted that there are some areas and challenges that he'd like some assistance overcoming. So I think I'm not worried about it. It's not really relevant. I'm not going to consider it.
Thank you.
Okay, go ahead.
Thank you, Your Honor. So trying to piece this together, given the testimony we've heard so far, these children had multiple caregivers.
Yes.
Okay. And at some point in time, they're staying with mom and dad and not grandma. Is that correct?
Yes. It was a more permanent situation prior to the CPS investigation. I had only figured that out during my investigation because on that particular day that I needed the children to have a medical exam, they were residing with the maternal grandmother. I then was asking, do you have a power of attorney or guardianship or any legal, authority over the children to take them into the doctor if you're able to do so. So that's how I discovered the power of attorney.
Okay. And did the children have insurance at that point in time?
No, there were insurance issues. The maternal grandmother tried to take the children to see Dr. Adanuka.
Objection, Your Honor. This seems like hearsay unless the worker has direct knowledge and viewed that. The information sounds so it's gathered from hearsay from the grandmother, which would be hearsay.
Yeah, my question was, did the children have insurance? We have a direct answer of no, not at that time. I can stop the question at that point. We can accept that answer as is. I believe that the testimony as it was going to be provided would give some background into how the children did obtain the insurance and eventually were able to go to the doctor.
So your objection is hearsay? So you're saying?
Yes, Your Honor. Unless she testified that I have firsthand knowledge of this, then you can answer any way you want. But if it's all from hearsay, I think we need to know the source. If it's her own personal observation, then it's not hearsay. But because this is a adjudication trial, which we can't have hearsay, then if somebody told her this, then it's hearsay. So I guess that would be my objection is I'm presuming it's hearsay because she didn't say my direct knowledge of this is.
So you don't want me to consider her answer that the children did not have insurance because it's potentially based on hearsay?
I'm presuming it's hearsay because she didn't say, I know this firsthand.
Very well. All right. Ms. Thomas, would you like to lay some foundation on how she would have come to understand whether or not the children had insurance?
Sure.
All right.
Ms. Miles, when you were part of your investigation, do you search any shared databases with other entities within the state?
Yes, we do also work with the payment side is what we call it, but they're essentially in charge of doing like Medicaid, food assistance, childcare assistance, any of the state benefits.
And did you have an opportunity to look up the children or the mother or the father in that system?
I did not look the children up, but I did email the supervisor over the payment side, addressing the concerns of the insurance, asking if they could sort whatever the issue was out so that the children would have active Medicaid to get those medical exams completed.
And based on your research with that system and your conversation with the payments director.
Objection. Conversation with the payment director is hearsay. Not as a court person.
Again, it's not being offered for the truth of the matter asserted. We're not asking the court to accept whatever the payment director said. It's the basis of her knowledge of whether the children had insurance or not at the time that she was investigating.
That's the nature of the question. Does she have insurance? And the insurance director says yes or no. That goes exactly to the essence of the question.
So, okay, to what end were you doing all of this in order to try to get them evaluated? Is that what you were doing?
Yes, so that they could be seen by a doctor.
And Your Honor, if I may, this also goes to reasonable efforts, and the court must continue to find reasonable efforts that are made in these cases at each proceeding.
I don't think the court rule says reasonable efforts excluding hearsay. Hearsay still is something there. It does say. I mean, it doesn't say including hearsay, Your Honor.
Okay, so I'm going to allow it for demonstration of reasonable efforts in order to prevent removal. And I will also say, it doesn't really go to the truth of the matter asserted. It just goes to show what she did in order to try to get the kids evaluated. So whoever she had to go to figure these things out, it doesn't really matter whether it's true or not. She just needed to get that goal accomplished, which does need to be evaluated by the court as to whether or not reasonable efforts were made to try to get the kids medical treatment. That's one of the allegations in the petition is that they weren't receiving medical care treatment. So if they tried to help them do that before removal, then that's important information I need to know. So for those reasons, I'm going to allow the line of questioning. You may continue.
Thank you. At the end of the day, were you able to assist the family in getting the kids' insurance?
Yes, they did have active insurance after I had emailed the payment supervisor. They were able to straighten whatever issue was out. I don't know what the specific issue was, but afterwards they had active Medicaid.
Okay. And during your investigation, what was your understanding? Like, I feel this is a repetitive question, but what was your understanding of where these children were during the month of May?
So it kind of moved around. Sometimes they were with mom and dad. Sometimes they were with grandma, sometimes they were with aunt. So it just varied, but primarily they were with mom and dad most of the time.
Okay. And to the best of, or when you were investigating, did you personally assist the family with any materials to help provide for the children?
Yes, I did provide various items for the care of the two boys. So diapers, wipes. I had dropped those off to mom at some point in the investigation.
And during that period of time, what was your understanding of mom's medical or health status?
So from my understanding, she did go to the hospital. At that point in time, she hadn't, at least I had no knowledge, knowing that she knew it was for a gallbladder. I just know that she was in pain for her pregnancy. So she would go to Hickman occasionally. I can't recollect how many times, but there were a few times that I know during the investigation she did go.
And other than the bruising that was apparent on the children, I guess at the beginning of your investigation, were there other instances of bruising or physical maltreatment that you observed with the children?
Yes, so additional bruising and marks were found on the children, which Ms. Rosas had let me know, and this was towards the tail end of my investigation. She, I believe it was after a holiday weekend, had called me that following day, letting me know that the children had new marks and bruises on their body and that she and Mr. Turns had separated. And additionally, The children were smaller, but I never seen them like unclothed to see like any ribs or anything to really say that they may have been malnourished. They were just smaller than what I would say a toddler looks like.
Ultimately, you as the investigator have to make a determination whether a petition is necessary to safeguard the children. Is that fair to say?
Yes.
What pieces of information did you have that made you concerned enough to file this petition?
Yes, so towards the tail end of the first investigation, when mom and dad both separated, they then began pointing fingers at the other parents, stating Mr. Turns would state that Ms. Rosas was abusing the children. Ms. Rosas would then in turn, accuse Mr. Turns of abusing the children. At one point, I even had a meeting with Mr. Turns after the bruising came up to figure out what is going on, why are these new marks showing up, where he had told me he felt the children would be better off in foster care than with either of them. And then additionally, a second complaint came in prior to the first one officially closing, indicating new marks and bruises again.
Any point in time when you were investigating, did you have concerns about the younger child's leg and any injury?
So the aunt, maternal aunt, had indicated at one point the youngest child was limping around and believed that the youngest child had sprained his ankle. When I first made contact with the family, the child was not up and moving around. He was just playing. So I didn't see him in any physical distress at that point. Again, he was not up and walking, so he could have exhibited distress had he stood up or pulled up.
Objection, speculation.
I think the question natures is the basis of her opinion and trying to understand if she had concerns. And so I think her talking through her mental process of developing or not developing concerns is appropriate.
Still speculation, Your Honor. She's stating.
She's not actually speculating as to what he was feeling or thinking. She was actually just saying he could have if he would have stood up. But I mean, and we didn't hear the conclusion to that, but she's not really formulating an opinion or even a full speculation.
Well, you
I
could
think
have.
she's-
Oh, sorry.
Well, you tell me, Ms. Miles, were you going to formulate a speculation or just tell
No,
us about your observations?
It was more so just to state I didn't have a chance to see him up and moving around. So just based on seeing him sitting down and playing, I didn't see any concerns.
I will accept that, Your Honor.
Thank you.
After the children were seen at U of M, so I think that was what, May 31st through June 2nd, 3rd? Yes. During that period of time, were you able to discuss the medical findings with the parents?
I was able to have an FTM and discuss these things. We did address the healing fracture that the youngest child had. At that point, Mr. Turns had stated that the younger child had twisted his ankle on a toy or somehow in the home and did exhibit signs of distress, that he was crying, but instead of taking the child to seek medical attention, he stated that they decided to put the child in the pack and play to keep the younger child more confined until he no longer showed any distress and crying or anything.
And that was a decision that the father made?
They didn't specify, but they were both in the FTM.
Okay.
Ms. Rosas was on telephone, Mr. Turns was in person.
Okay. And as part of reasonable efforts, did you have a conversation with them about nutrition for the children?
Yes.
Part of your petition also includes this element of domestic violence. Why did you include that in the petition? Why was that a concern for you?
So after that holiday weekend, when the parties had separated, and Ms. Rosas had called me to let me know that there were new marks and bruises, and I had went out to the home, met with Ms. Rosas, seen the children. That is when she expressed to me that there was a history of domestic violence in the past. And then I had given her DD resources, so like the national hotline, gave her the phone number for Catherine Cobb, and encouraged her to reach out to those resources as well, because there was always a chance at that point that if there was domestic violence and Mr. Turns could return back to the home. So I wanted to try to be proactive and get Ms. Roses out. But prior to that, neither one had mentioned any concerns of behavior.
Okay. During the second part of that investigation, we heard the doctor testify that in the notes there's an incident of spanking a child. Did that draw any concern to you?
It did draw concern. I do understand that corporal punishment is legal in Michigan. However, we had an FTM prior to that incident occurring. And part of our safety plan that we discussed voluntarily that parents agreed to was that they agreed to no physical discipline. And I believe it wasn't a long period of time after having that conversation that Ms. Roses then proceeded to use physical discipline or spanking towards one of the children in the hospital.
Prior to your investigation, did you have the opportunity to review CPS records from other states that the family lived in?
Yes, 2 of the states. I was not able to obtain records for all of the states that they resided in.
What 2 states did you have records?
Kentucky and Texas.
And when you're formulating your opinion as to whether there's risk of harm to these children, did you use any of that information in those prior CPS records from Kentucky and Texas?
So I was able to use the information that came from Kentucky. Texas, I had made that request very early in the investigation and had not received the Texas records back until weeks after my investigation was closed.
I'd be objecting, Your Honor, as far as any use of the one report from the other state, as that indeed would be hearsay. Say we have the actual record and it's been submitted, that's one thing. But using a history from another state would indeed be hearsay as part of her formulation of a decision on this is what she's answering. So form the basis of her decision.
If I heard correctly, then Mr. McFarland just conceded that it's not being used for the truth of the matter asserted.
No, it is a basis of the grounds for a decision. So yes, it is being used for the truth of the matter asserted. The out of state records do have a bearing in her decision, is what I'm hearing.
Well, I think they have to, don't they? Isn't that, what you tell me, Ms. Miles, is it required for you to review whether or not they have CPS history?
Yes, we do have to review in-state, and if they report any out-of-state residency within the last 10 years, we have to request those records and review them as well.
And does that factor into whether or not you decide, like, how you categorize a case or whether or not you decide to file?
It doesn't necessarily help us decide whether we're going to file or make that sole decision for us, but it does help us identify a pattern and recognize that if this is a situation that is continually occurring, that further supports preponderance of evidence if they're continuing to indulge in that same behavior.
When you're looking at out-of-state records, is there a way to tell whether or not, like I know for us, anyone can make a complaint, obviously, but if it's substantiated, is really what we need to know. Is that the same in other states that you've seen?
Yes, so they may have a different process to get to that point, and there's different minor details, but they still go through an investigation. They still do similar risk assessments, home visits, and ultimately make that decision on the end to decide whether to confirm an incident or an investigation or not to confirm. And they do include a summary at the end as to why they got to that disposition or finding.
All right, Mr. McFarland, we're going to allow it. I will certainly consider it for not necessarily the truth of the matter asserted, but it does factor into her obligations and her investigation. And obviously, you're welcome to cross-examine. I am also interested in finding out if the investigations in other states were substantiated or what level of credibility they found on those pieces as well. I look forward to that, but I'm going to allow the line of question.
Thank you. So prior to you filing the petition, you did not have access to the Texas records, correct?
No, just Kentucky.
And in the Kentucky records, had the parents been found to have substantiated according to their local CPS standards any physical abuse or neglect on any minor children in their care?
Yes, there was a substantiated case against both parents regarding the child who was a minor at that time, Amber Turner's Jarrell's daughter.
What were the general allegations, or what were they substantiated on?
They were substantiated on physical abuse. I'm not off my memory. I'm not sure if that's the exact term that they use, but it was for physical abuse. And Ms. Roses had attacked Amber Turns and bit her several times on her body. And it was substantiated against Ms. Rosas for physical abuse and substantiated against Dad, I believe, for failure to protect.
And when you read that, did that raise any concerns about the patterns or the allegations that you received for the younger children here in Michigan?
Yes, because what we received, of course, had to do with physical abuse. And we had 2 minor children that had repeatedly, turned up with bruises during our 30-day investigation, and seeing those records, already having a substantiated case for physical abuse against a different minor child was concerning.
As relates to the newborn, did the mother's demeanor towards hospital personnel give you any concern about the safety and well-being of this newborn?
So I was not the on-call worker, so I didn't have direct conversations, but as we kind of spoke about earlier, I did request those records. And I did still go through them. As I was the assigned investigator, I had to still follow through all policies and procedures. And there were notes in there stating mom was aggressive with staff. There's a detailed note in those ProMedica records stating where mom had became verbally aggressive and had told the infant child to, excuse my language, but to take the fucking pacifier. At this point, from my understanding, this is a day-old baby, and they can't choose those things. So that is definitely concerning, her behavior towards an infant child and staff as well, but more so this infant baby that she had just had.
You've heard testimony today about all the children essentially born to these individuals are pretty small. Is that fair to say? I believe your testimony also indicated that they're pretty small. Are you, when you did like the bridges or the payment assistance search in your investigation, that point in time, was the family receiving any financial assistance for the children in their care?
They were receiving food, I almost said that, food benefits, as well as Medicaid once we had gotten that straightened out for them.
Okay. And so, okay. With that, Your Honor, I have no further questions of this next. Thank you.
Okay, cross-examination, Mr. McFarland.
You were present when the doctor testified earlier, correct?
Yes.
You heard the doctor say that with medical certainty, she couldn't say that the injuries were caused, at least the broken bone or the cracked bone, by a parent. You heard her say that, correct?
Correct, but she also cannot rule out the abuse either.
Did you talk to her in your investigation?
Yes, I did have a conversation with her.
Did you include in your report that the doctor could not rule out that it was not intentional?
In the investigation report, yes, it would have been included.
Okay. So nothing further.
Ms. Heiss.
In the course of your investigation, did you have a chance to look through actual medical records by the first-hand providers for these children?
For like a pediatrician,
yes,
like established. I did try to request records from Dr. Adenuga, as I was told that's who they were previously seeing, but I was only able to obtain one visit for about a year prior, but no established care was done, and no other pediatrician names were given to me by either parent or family members.
But there came a time when you reviewed record from ProMedica, is that correct?
Yes.
And that was from Lenawee County?
Yes, on May 17th, that was the initial medical exam I requested them to take the children.
And this is when mom and dad took the child to the emergency room with the direction of CPS?
Yes.
And the outcome of this report generally is that there was not a new CPS complaint made for broken bones or malnutrition, correct?
Correct.
Your Honor, this is on the state's exhibit list, and I would move for admission of this. I don't think the state has done it until now.
What is it?
It's a ProMedica report dated August 9th, 2024. It's on their discovery list.
Mr. McFarland.
Opposition.
Okay. Ms. Thomas, any position?
Your Honor, I would agree, or concur, or join in agreement with Ms. Heiss to admit the medical records as part of the exhibit. We do have included the affidavit of certification that it is a medical record kept in the ordinary course of business, written by individuals with first-hand knowledge of it. I believe it is appropriate. It supports the petition and also Ms. Mayo's testimony regarding the concerns of it.
All right, I'll receive it, and that would be petitioner's exhibit, I'll call it petitioner's exhibit A for today. I am going to say though that we can appreciate that it's probably got what you're saying. So we'll take it for, because I don't have any objections to it, but.
Well, I guess I have a question. Does the court want to have the hearsay redacted, or is the court going to do that on its own? That was my presumption, but I guess I really shouldn't presume.
Well, that's, Mr. McFarland, that's really up to you to make any objections on that point. But if you don't have any objections, I certainly will take into account that it's mostly hearsay. I don't know how much value I can really assign to it because of the amount of hearsay that it contains.
Oh, I have reviewed that, Your Honor, and it is almost exclusively hearsay. So I am going to change my opinion and voice an objection. I think I have it right.
Pretty systematically deny the admission of CPS investigation records and medical records because of the level of hearsay and the amount of hearsay in those.
So then I'd ask the record to be stricken regarding the doctor's ultimate decision that there was no sign of physical abuse at that time. Ask that be stricken from the record as hearsay.
Any objection?
Well, I think that was her actual testimony here today. She's asking that the actual testimony be stricken. If that's my understanding, that's not hearsay.
Yeah, I just want to make a statement that I believe that this would adequately fall under MRE 803, an exception to the rule against hearsay, subsection 6. It's a record of an act, transaction, occurrence, event, condition, opinion, or diagnosis meeting the following criteria. It was made at the time by or from information transmitted by someone with knowledge. It was kept in the regularly conducted activity of the business. Making the record was a regular practice of that activity. And then those conditions are shown by the custodian or other qualified witness or by a certificate that complies with the rule. And the opponent does not show that the source of information or the method of circumstances of preparing indicate a lack of trustworthiness. And that was my whole purpose of including the affidavit of certification, knowing that without that, it would be hearsay, but with it, it is an exception to the hearsay, to the rules against hearsay, sorry.
Mr. McFarland?
All right, I think it's really sort of a balancing test here, and the person who signed that affidavit is not here for me to, the statement is not here for me to question. That person's not on the witness list for me to question. So I still think that when we weigh everything here, I think that a lot of hearsay is going to come in on possible appellate issues. So I'm going to have to stick to my original suggestion that this is more hearsay. It should not be excluded. Should not be included. That the actual drafter of that could have been subpoenaed, and that would have been firsthand evidence and testimony.
Well, additionally, Your Honor, MRE 902 subparagraph 11 dictates the certified domestic or foreign record of a regularly conducted activity, which in most part does mimic 803.6 and the conditions through A through E. And I had provided the parties with notice of intent to use this. I provided the affidavit of certification. I put it on my witness and exhibit list. And I think that, again, based on those circumstances, it does fall outside, or I'm sorry, it falls within the exceptions to the rule against hearsay.
Which one? 902 what?
11.
Just on that right now.
May we approach the bench?
Let's take a brief recess, actually. I'd like to talk to the attorneys about this as well as address. Mr. McFarland, did you want to, mostly what we talked about, frankly, was the objection that was just made, as well as asked Mr. Turnus to call back in by way of Mr. Brooks so that he can testify next. Mr. McFarland, remarks for the record, objections further?
Well, I think that's an accurate representation of our sidebar back there. my understanding, taking a look at the exception to the hearsay rule, there is a section initially cited for objection to the hearsay rule, which does account for medical records, and it specifically says medical. Under the section that the attorney for the agency is trying to get this in, it does not specifically say medical records. I'm thinking that'd be like timesheets and things like that, that it would not go to the essence of the case asserted. I think this does. I think it's going to contain multiple instances of hearsay, which are not permitted under an exception because these are medical personnel with testimony being used to prove a medical assertion of medical neglect or medical
Evidence of medical neglect.
evidence of medical neglect. Thank you, Mr. Brooks. So that would be my position, that they should not.
Further comments from the other attorneys?
Just to restate my position, that these records would be under an exception to MRE, under a hearsay exception under MRE 803, 4 or 6 or both, and that they're purported to be records from the birth of the youngest child, in this case dated September 18th, 2024, and they do have an affidavit of certification attached. I move for their admission.
Any comments?
No, Your Honor, I believe I made my argument before we took a recess. Thank you.
Your Honor, I do have one other statement, and it's that this is an out-of-state document. I'm not sure that this exception really applies to out-of-state documents where you also have the ability to go through out-of-state courts to actually subpoena the actual individuals who provided these statements in there. So that's a further argument that I have. And this is in, I believe, Lucas County, Ohio, where these generated are from, not Michigan.
Your Honor, just to that point, that was the MRE 902 subparagraph 11 reference.
Which does not mention the word medical.
That's just about the verification, I think, right? Is
Whether it's a foreign or domestic record of a regularly conducted activity.
yeah, so that says to your argument as to whether or not it matters that they're from an out-of-state facility. The seal seems to have been, not the seal, but the certification seems to have been contemplated by the court rules, whether that's from an in-state or an out-of-state.
Is that notarized? I'd have to go back and take a look. Not sure.
It's an affidavit.
Well, I can tell you, here's what I've decided to do. Assuming there's no further issues with the certification, which there does not appear to be, I will accept it as a record of regularly conducted activity. I do think that there are also some statements, I'm sure, in there that would qualify for statements made for purposes of medical treatment or diagnosis in connection with treatment, which is 8034. But I will say that I'm sure also that it has some hearsay within hearsay in violation of 805. So as I review it, I will take all of that into account and make sure that I rely on the bits that are reliable, if you will, and would otherwise be. Further argument on the certification, Mr. McFarland?
Well, I'm just thinking, how are we going to know that we have written decision which says I took into account this, it is hearsay, I took into account this, it's not hearsay? I guess that's the issue I have with the court's position, Your Honor.
Well, I'll be giving you my opinion on whether or not I think jurisdiction is appropriate and whether or not I rely on anything out of those documents. You'll be well informed.
Understood.
Further argument on the certification?
No.
Mr. McFarland?
Well, I don't think it's notarized, so I know it needs to have a seal to be valid out of state. So, see where there's notary required on there. So nothing further.
Very well. Okay. Deputy Ames, would you be so kind as to pass up Petitioner's Exhibit A? Thank you.
Thank you. So just a couple other questions. You had a safety plan with this mother at some time where she was advised by you not to use corporal punishment while your case was open. Is that right?
Yes, we did have a verbal safety plan that we all agreed on. Myself, Ms. Rosas, Mr. Burns, we did not have it written as she was not in person, but she did verbally agree not to physically discipline children.
Okay, and then Ms. Turnez indicates that before the infant left the hospital, are you familiar with the infant? Were you investigating that case as well?
Yes.
And that the child had a 10-ounce meal. In your training and your expertise as a social worker, do you know if that's a developmentally appropriate amount of food for a child that age?
Not for an infant that's days old.
What would be an appropriate meal size for a child that size?
So it would
Your
depend.
Honor, I'm objecting. I haven't heard the qualifications in nutritional requirements for a infant child. I know she's a caseworker, but I haven't heard any testimony about her expertise in this particular area, or that caseworker has any knowledge of that.
I will examine her for foundation, Your Honor.
Okay.
Do you have any training in developmental nutritional needs of children?
Not any specific certifications as far as like medical side, but we do go through training as CBS investigators regarding the developmental stages for children and what kind of to like look out for.
What would you consider then, what is your training tell you is a typical meal for a day or two old baby, the size of the meal?
It should be within milliliters, not ounces. Maybe a couple milliliters depending on how.
Could you speak up, please?
Sorry, it should be within the milliliters, definitely not ounces. 10 ounces is extreme for a 2-day-old infant child.
Thank you. I have nothing further. Thank you.
Any other questions for this witness?
How many milliliters is 10 ounces?
I wouldn't know off the top of my head, but I do have an infant child myself. So 10 ounces compared to milliliters is a substantial difference.
Well, you're holding your fingers. Court can't take a record of that. So how high are you holding your fingers for 10 ounces?
I'm not sure what 10 ounces is. A much larger difference compared to milliliters.
You don't know the conversion, do you?
No.
Nothing.
Any other questions for this witness?
No, thank you.
Last opportunity. Thank you for your testimony. We return to your seats. As I understand it, we will be having the testimony of Mr. Gerald Turnus next. Is that right, counselors?
Yes.
Well, has he called in, Your Honor?
He's here. FBAs, where in Mr. Turnus, please? He's appearing to us by phone.
Your Honor, just for purposes of Mr. Brooks, it is 2:55.
Let's deal with this man, and exactly at 3 o'clock, I'm gonna leave.
Mr. Turnus, can you hear me, sir?
Yes, sir.
I can't see you, so please raise your right hand and let me know it's raised.
It's raised.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Turnus, this is Nastasia Thomas, the counsel for the department. Can you hear me okay?
Yes, I can.
Okay. I just want to remind you that you are not on trial today. You have already entered a plea, okay?
Yes, ma'am.
Okay, so your statements here today are only to help us understand the home environment of your children with their mother. Do you understand that?
Yes, I do.
Okay. On or about when this case first started with CPS in late or May of 2024, at that point in time, were you in a relationship with Miss Rosas?
Yes, I was.
Okay. And during that period of time, did you have any concerns about Miss Rosas, her ability to safely parent your children?
Absolutely.
Can you explain why you were concerned about her ability to parent your children during that period of time?
Well, because when she wasn't doing her marijuana or her other drugs that she decided to do, she had an anger issue, and then she took it out on the kids when they started crying or screaming or got hungry or anything like that. Or if they had a nightmare, instead of comforting the kids and getting them to go back to sleep, she'll cuss at them, scream at them, and beat them until I have to get up and intervene and tell her to leave the room so she can calm down and I can get my kids to calm down.
And with that, Your Honor, I've got to go upstairs.
Hey.
I'm awfully sorry.
Mr. Turnus, your attorney was here for the questioning up to this point, but he's got to go upstairs for another hearing. Are
I'll
you
be back just as fast as I can get.
continuing to answer questions as a witness without him in the room?
Yes, I can.
All right, go ahead.
Thank you. You mentioned she would, I believe your testimony was to beat the children. Can you elaborate what you mean by that?
Sometimes, I mean, pretty much you name it, she's done it. there's
Mr.
proof
Travis-
that, because go ahead.
No, go ahead, continue.
I was going to say that as May 27th, I was actually not around my kids from May 27th to June 7th. She had my kids, and it was clearly stated that they still had like new bite marks and looked like burnt marks or whatever that was on their bodies. I just wanted to clarify that up.
Yeah, and had you personally observed her bite the children or burn them with anything?
Just only the biting, not really the burnt. The burnt thing was kind of new to me when they told me that, but the biting, yes, and I've argued with her numerous times to stop.
Objection. I'm objecting about burning. He's now indicated it's not his personal observations when they told me about the burning.
He's not acknowledging that it's true or false. He said he didn't know about it. He said it was new to him, the
I
allegation.
thought he said my client bit and burned the children. I thought that's what the testimony was. Now he's saying that he did not see that. That's what it was revealed to him, which would be hearsay.
Okay, Mr. Turnus.
Well, actually, if you was to actually listen, I said from May 27th to June 7th, I was not around my kids, and I got pictures and the documents from the CPS stating that it looked like they had burnt marks. So I'm not vouching that it's true or not. I'm just saying I don't know. I'm just going on what I've read from them. But the biting, yes, I witnessed that myself from my own eyes.
I think that clarifies.
He does.
Thank you.
And Mr. Turnus, earlier we heard testimony from your now adult daughter, Amber, and she had indicated some of the same conduct that you've just testified to. Did you ever observe Ms. Rosas be physically assaultive towards your older daughter, Miss Amber Turns?
Yes, all the time. I even had to call cops and CPS on that situation too. And we was in Cadiz, Kentucky at that point. And Jackson, Michigan is where the cops actually got involved in. And all they did was put Angel Rosas in jail overnight and let her back out in the morning. And you mentioned in your testimony earlier that she had, I believe you said, anger problems. Is that correct? Yes, ma'am.
How did you observe her anger to be expressed?
Violently. That's all she is. She gets violent a lot. She's actually hit me quite a few times too, but all I did was try to restrain her, just to get her to calm down. And
how would you describe
your relationship? Our relationship was actually rocky from half the first year that we were together. And it just kept going downhill from there. I kept fighting with her, trying to stay with her. That way the kids can have a mom and a dad. Fighting with her family, because they're trying to get us split up and hooking her up with other people. And it wasn't very good. I was actually staying with her to get the CPS involved so she can either get help, my kids can get help, and everything can get fixed.
Okay. Do you, when you guys would fight or argue or there was physical aggression towards one another, were your children present?
No.
Okay. I have no further questions of this witness, Your Honor.
Mr. McFarland?
One moment. There we are.
Yes, nice.
No questions, thank you.
Okay, thank you for your testimony, Mr. Turnus. That's all we need from you today. We're looking forward to seeing you on October 14th at 1:30 by phone or in person, okay?
Yes, ma'am.
All right, you have a good day.
You too, ma'am.
Bye now. Anyone else you'd like us to hear from, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No witnesses, Your Honor.
Ms. Heiss?
No witnesses, thank you.
Closing arguments, beginning with Ms. Thomas?
Thank you, Your Honor. At this time, I believe that the department or us as petitioners, we have met our burden of proof by preponderance of the evidence that at least one of the allegations contained in the petition are true, sufficient enough for this court to take jurisdiction under MCL 712A.2B1 or 2. In the petitions combined, we have alleged that jurisdiction is proper under both subsections. Today we heard from medical a board certified pediatric medical doctor who specializes in child abuse and neglect. Her testimony wholly supported that these children had experienced some form of neglect, whether that was medical or physical. She acknowledged the fact that these children at some point in time, that these children also, their bruising was consistent with children of their age who partake in age appropriate or developmentally appropriate activities and may experience the same type of bruising and or fractures. And that in and of itself is not the issue. The issue is what happens afterwards. Ms. Rosas has indicated that she did not provide care for her children because they were under a power of attorney, yet somehow they were still in her home and in her care because then Mr. Turnus had to watch them while she was in the hospital. The information that we received from Ms. Rosas today does not paint a clear picture of who was actually in charge of these children. Regardless, she was the legal parent and had the responsibility to safeguard them, to provide for them. Per her testimony, the moving around prevented them from having adequate or normal medical care, which would have brought to their attention that these children were not just at the bottom of the bell curve on averages for size, but in an extreme, under the first percentile for their age and gender. We've heard about the food that she would have provided them or did provide them, yet the medical records don't indicate or don't show us that it was sufficient enough to maintain their well-being. Similarly, with a healing fracture, at least one of the parents, and Mr. Turnus has already taken a plea, so I don't want this to be shifted to him, but per Ms. Miles' testimony, both parents were aware that this child was experiencing pain of some form, and the answer was to keep him in a playpen until he was feeling better. They did not seek medical attention at that point in time, and he had to allow that to heal without further medical intervention. We've also heard about Ms. Rosas and her conduct towards her children, the spanking. And as Mr. McFarland has noted in his questioning, verbal punishment isn't illegal. And again, we're not faulting her for using a discipline technique that is reasonable, but it does add into the other concerns that we've had a parent alleging the mom has punched, pinched, bit the children, hit, kicked, which was consistent with another individual's experience with the same mother. She herself has testified that in the relationship with Mr. Turnus, they would verbally argue and be physically aggressive with one another. There's competing testimony. Were the children around during that? Mr. Rosas says that they were, and if they were, that would pose a substantial risk to their mental well-being and also pose a risk for psychological harm.
Included his testimony.
This is further supported by the medical records that this court has accepted on page 33 of that packet. The nurse that was providing care for the newborn witnessed mom being verbally aggressive with staff and the baby, telling her to take the fucking pacifier. Mom's testimony at first was, well, I said it in a gentle tone because I was exhausted. Then when she's crossed on it, she doesn't recall saying that at all. Your Honor, these children have presented in a way that shows there is a significant risk of harm to their physical health and emotional well-being, that the home environment with Ms. Rosas is not appropriate for them. Her request is that the court give her time so she can demonstrate her parenting skills, except for she had an ability to demonstrate her parenting skills for 2 years and 3 months with her oldest child and a 16-month-old. She said today she could take just one of the kids because of her home environment. Yet we still have concerns about her ability to parent a newborn, as testified to by Ms. Miles and even Ms. Rosas. This struggle to get a child to latch onto a bottle or having to go through so many different nipples, and sure, that might be able to happen, but the frustration that follows it is not appropriate or common. And we had a medical doctor also speak to things that maybe a reasonably prudent parent would do, and we are not seeing that with this mother. And with the newborn, again, I think that her testimony of a 10-ounce feeding demonstrates the lack of knowledge when it comes to what's developmentally appropriate for a child of that age. In the medical records, there's many educational resources included in that, and the medical records indicate that these resources were also provided to mom through attempted teaching from the medical providers, and indicating that how much a child will eat, indicating how frequently a child of that age will eat. And to have a mom still almost 2 months later not have that understanding is very concerning. I think that with all of those things in place that have been testified to, this court has sufficient evidence to find that jurisdiction is proper, and that it is necessary for this mother to partake in a case service plan to develop skills as a mother. Particularly even with anger management, it seems that this is a long history of inappropriate discipline techniques. This is an individual who has demonstrated volatile behaviors and being aggressive with individuals from a newborn to nursing staff to a romantic partner to a teenager who's living in her home and her young children. And so for those reasons, Your Honor, I am asking the court to consider all of that evidence and adjudicate the mother. Thank you.
Mr. McFarland?
Your Honor, MCL 722.1555 is indeed the statute governing delegation of parental rights. And Section 1 states that by exercising a power of attorney, a parent or guardian of a minor child may temporarily delegate to another person his or her powers regarding care, custody, or property of the minor child under this act. Parent may also revoke the power of attorney. There's been no evidence presented that after my client executed a delegation of parental rights that it was indeed nullified by her. As a matter of fact, by operation of the statute, she's not responsible for the minor children, and she's delegated her care and custody of these minor children. So I don't think that's really a valid argument here. We have the testimony of the doctor who cannot draw a medical conclusion that that at least as far as actual abuse, that this could medically be attributed to the parents injuring the child rather than self-injury by the child. Matter of fact, we don't have any harm as a result of this, as it seemed to be healing fine. Another issue that was brought up was the child tested positive for marijuana in the system. My client testified that a medical expert, a doctor, told her that was okay to use that. We've heard no testimony to the contrary. Matter of fact, we have no medical testimony indicating that the child testing positive for THC was harmful to the child, Your Honor. My client was maybe not as polite as she should be in the hospital with the nurse staff, medical staff. She had given birth at 2-something in the morning, or close to 2 o'clock in the morning. Stayed, she didn't get to bed until 5. And at 6 o'clock, they were waking her up again. I think anybody who's been in labor for 15 to 16 hours, as she testified, would probably be quite ornery. I think that's what we're seeing here. Nothing extraordinary. Also heard her testify as to the issues she's had with the other children and the youngest child of this amended petition. That they had issues getting a proper nipple on the bottle for the child to consume its nourishment. But once that was worked out, it seemed to have been resolved, the issues, but then the child was immediately taken from her care and custody. I also have testimony that from the medical doctor that we did, I guess what we lacked from the medical doctor who testified was when the 2 older children came in that they were malnourished from observation. It wasn't until the children were weighed, until the circumference of the head and everything else was conducted, that a determination was made, in the doctor's opinion, of improper nourishment. But that's not something that they could tell just by looking. I'm not sure how a parent would tell about that. Once again, the question is it really even parent's responsibility when that has been delegated. It would seem as though the person who should have been brought, nobody's questioning the validity of this delegation of parental rights. Is the person that should be in front of this court is the person who has the delegation of parental rights at that time, and not the parent who delegated that. That's the whole purpose of the statute, Your Honor. So that's another issue that we see. My client has had other children. She seems to have been transient, lower economic scale. There's no law that says, nothing cited that you must take your child to wellness well checks at a certain frequency. I don't know that that is neglect in not doing that, Your Honor. I think we're stretching that. I don't think that it's been clearly demonstrated to this court that it was on the oldest two children, in which there is a delegation of parental rights, that my client had any responsibility, as these rights have been delegated, as acknowledged in the petition that there was a delegation of parental rights. I think it's misdirected to the party. My client was not asked on the record. There is no testimony or any other evidence, once again, that there was a revocation, that this was voided. As far as the youngest child, I think we're stretching it as far as mother not being able to properly care for a child. We heard her testimony. Didn't hear the testimony of anybody who witnessed firsthand her interactions with medical staff, basically just my client. So at this point, I do not believe the agency has met its burden, and we would ask that this court not take jurisdiction. Thank you.
Ms. Hines?
Yes, thank you, Your Honor. I have not been in receipt of a delegation of rights, and it is not entered into exhibit today, so we have mother's word about a delegation of rights, but it is here to be inspected appropriately. So, the credibility of the mother, who is the one who told us about the delegation of rights, is in question. I don't know if she was in error about 10 ounces of formula for a 2-day-old infant, or whether she was just misrecalling, but her credibility about gently and soothingly saying that the child should take its pacifier with the F word in there, I don't think that her credibility is something we can rely on. What we can rely on is the science, and both of the older children were less than 1% of the weight that their peers are at the same age for the same sex of child. That the doctor testified was because of a deficiency in not enough calories to support normal growth. That is, we are not here asking for termination of this mother's rights in any way. What we're asking for is time to work with her. She had 3 children in 3 years, and we can't allow this risk of harm. There is a danger of substantial risk. There is a danger, there has been a substantial harm done to these older 2 children, and we can't anticipate that her parenting of the older 2 would be the same as the younger 2, even if we didn't find direct neglect at minimum, or failure to demonstrate parenting sufficient to take this the youngest child home with her and to have the child placed with her. The things that happened while the children were in her care, including treating the leg injury by a few days in the playpen, is just not sufficient protection of the children's rights, right to be free from harm. I would ask you to consider, as my recommendation, that you find that there was substantial risk of harm for these children, and that they take jurisdiction over the mother. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of the trial today on the adjudication, and that's as it relates to petitions 1 and 2. The court has previously removed these 3 children from the care of their mother, and today is tasked with determining whether or not there's been a preponderance of the evidence that Angel Rosas is the parent in this case violated MCL 7128.2b. I do find there is a preponderance of the evidence of a violation of the provisions as set forth by the department. That we have a parent here who has failed to provide medical educational, surgical, or other necessary care for the health or morals of the children has created a substantial risk of harm to their mental well-being, at least of the oldest two children, and actually of all three. And that her current, and that the environment at the time of the petition's filing and currently still does demonstrate an unfit home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of Angel Rosas. And this is why. As it relates to the older two children, there was a very strong witness here today, the doctor who was certified as an expert in the area of child abuse pediatrics, who testified that as it relates to the older two boys, that they did come in, as Ms. Heiss pointed out, significantly underweight, not even matching the 1% of their peers. And we had, unfortunately, Ms. Rosas testifying on the stand repeatedly that they felt heavy to her, for example. Still is unable at this time to understand the deficiency or the disadvantage, significant and lethal disadvantage that she put her older two children at as a result of their time in her care. I also find it very disconcerting, to say the least, that one of these children had a broken leg and was not treated for that. For example, was not offered any kind of reprieve from the pain that would come along with having a broken leg, and was rather confined to playpen, which I mean is something, I suppose, but to not have any treatment and to not have enough food and to not have any care for the potential pain that the child was in at the time is very concerning. It's certainly a violation of the statute. It's neglect of his medical needs. It's harmful to his mental health to be in that condition for a week at a time under the food deprivation, as well as the pain that he was in. It's very concerning that both parents really, but specifically Ms. Angel Rosas, considers these to be normal ways of caretaking for a child. So there's certainly a violation here that has contributed to the risk of harm, or has contributed to harm to their mental health, the two older children. There's also research out there that talks about even in utero, how exposure to parental aggression and anger can affect a child. And here we have an example of a mother who is expressing that to her newborn child. She did admit that on the record, and I do think that that did happen. I do find the credibility of more than one witness that recounted that and her admission to substantiate this, that at her hands there have been instances of abuse by the other two children and neglect to their needs, their nutritional needs specifically, and medical needs, that continued to be a very distinctive and pervasive part of her parenting with the youngest child. That was demonstrated by the medical records in the sense that I continue to see the pattern. The older two being deprived of nutrition continued to be a pattern throughout the time that she was in the hospital with the baby. There are numerous times where the nurses came in to try to talk with Angel Rosas about how often her daughter needed to be fed and how much. I did peruse those briefly. Obviously, I haven't had a chance to read all the way through them, but it is a pervasive theme about feeding and when to feed and how often to feed. This was a child who was not even 5.5 pounds at the time she came into the world. And so expecting that she would take in 10 ounces of formula, which is a pretty significant portion of her weight at the time, is very, very incredible, especially looking at the remarks about the child coming in. It's over and over again in these records that this child was underweight for her gestational age. She continued to have trouble feeding, which was why it was important to continue feeding her in small amounts over frequent periods of time. And Ms. Rosas was frustrated frequently about that, exhausted, tired, asked the nurses effectively to do that for her. And this is a very distinctive problem that is being demonstrated both towards, you have the pattern with the older two children and now this pattern with the youngest child within 24 hours of her being in this world. So I certainly stand firm on the removal order of the first two children and of the infant, considering the circumstances. I also think that there is a preponderance of the evidence that in the home of Ms. Angel Rosas, there are aspects of not only that neglect as it relates to food and medical attention, but also physical abuse, which clearly creates mental harm as well as physical crime or physical harm to the children. And that was substantiated by the investigation. There were indications of that pattern, as Ms. Deja Miles indicated, but that was also substantiated by one of the children that lived with her for a period of time and ended up being removed. And so the record should reflect that Ms. Angel Rosas has left the courtroom, which is not hopeful because at the end of the day, the reasons that I have to articulate that jurisdiction is appropriate also form the basis for the services that we'll be asking her to undertake in order to get her children back. She also wants a chance to do that, and I do find that that's appropriate, but we'll need her to look at the definition of abuse, the definition of neglect, the definition of nutrition, and decide for herself if she truly wants to learn what it takes to be a safe mother for these children. The abuse was substantiated both by Amber Turness as well as Jarrell Turness. And there was not definitive evidence that the older two children suffered this, but there was indications that at least one of the injuries did look like a bite mark. So it's not too much of a stretch of the imagination, frankly, where this pattern would have been extended onto the two children that were in her care, her older two sons. It seems to be a consistent way that she expresses her frustration, which certainly needs attention. There were other instances of these patterns, but those were the most persuasive that the court finds do support the preponderance of the evidence that under those three sections that these children need to be under the jurisdiction of the court, and so does Ms. Angel Rosas. She needs to undertake some counseling, some psychological evaluations, some classes on how to overcome these barriers so that that risk of harm associated with allowing her to care for her children is alleviated. As I understand it, the two older children, they've been asked to be removed from the place where they're at now, in part due to some of the behaviors that are frankly things that are mimicking some of the patterns that we're seeing here. The oldest child appears to be biting on a regular basis and is causing issues such that he's compromised the first place that they're at. So they need support. They were severely underweight. Okay, so the other bit about the underweight that I wanted to add to the record was the testimony of the doctor, wherein she noted that she did look for other reasons to see why these children would have been underweight and ruled out that any medical diagnosis would be causing that. And then noted further that while the children were in the hospital, that they gained weight. They gained several ounces just over the period of time that they were in the hospital. So it further substantiates all of the concerns that were brought before the court as far as these different patterns in the home of Ms. Angel Rosas that certainly need attention, both for her own well-being, but especially for the well-being of the children that she's brought into the world. All right, I'm inclined to set her initial disposition on October 14th at 1:30.
One moment, I think that day I am going to be out. I believe that's a Monday, is it?
It is.
Yes, I will not be here.
Well, that would have been excellent information to know earlier.
I know I've said that in other cases about this, but I don't have it down on the calendar. Did you mention that date earlier? I didn't catch
Yes,
it, I'm
that's
sorry.
the date and time set for the pretrial on Mr. Turner.
I'm sorry, I did not catch that.
Okay. Are you going to be in on the 15th?
Oh, yes.
Okay, looks like there's a different case set at 8 o'clock, but if you think you could be back here by 9 o'clock, I'd be inclined to set it at 9, or
fine.
actually maybe at 11. I think I've got an opening at 11. Any preference, counselors?
Either's fine with me.
Let's go 11, just in case your case upstairs goes over.
October 11th.
October 15th at 11. And that'll be the initial disposition for Angel Rosas as it relates to both petitions and all three children. They're in the safest and least restrictive environment at the time under the circumstances for all the reasons that I've articulated. I'm hoping I do have a proposed case services plan with her name on it in the proposed exhibits for the review that's going to be held today in conjunction with the pretrial. We'll go over that at the next juncture, but I raised that, Mr. McFarland, to let you know that it appears she has already looked at some services.
I'm aware of that, Your Honor.
So that's encouraging, and I really hope that she is able to take advantage of some of those supports between now and when we come back to get started on those things. But all the children will remain in their placements until we come back to look at the case again in October. Are there any questions?
No.
All right. We're here today. We're scheduled for the initial disposition on petition 1 for Mr. Turness. There's also been a pretrial set on petition 2 since DNA is still pending for that child. I was able to chat just briefly with Mr. Brooks and Ms. Thomas before we got started. So Ms. Heiss, I'll fill you in and I expect to hear this from Ms. Thomas anyway, the DNA is not back yet on petition 2. So I'll let her elaborate more on that, but that's what's set for today. So I'm assuming we'll be adjourning petition 2, but I look forward to understanding exactly what your position is after appearances.
Lee Heiss, lawyer guardian ad litem.
Natasha Thomas, counsel for the department. Miss Kristen Smith is the foster care worker. Not sure if she's logged in.
Yes, Kristen Smith, foster care worker, Catholic Charities.
Michael Brooks, I represent the father, Gerald Turnus.
Have you heard from your client?
Gerald Turnus.
Oh, there he is.
This
Good
is
you are
Gerald
here.
Turnus.
Very good. Welcome. All right, Ms. Thomas, would you like to give us an update on what's happening on petition 2?
Yes, thank you, Your Honor. From my understanding, the DNA test that was scheduled for the youngest child that is subject of petition 2 has not been completed yet. The new referral date is set for November 22nd. So I would anticipate those results to come back probably around the time that we would have our first review.
All right. Did you wish to take any, well, Ms. Heiss, let's go back to you for a second. This is our initial disposition on petition 1 from Mr. Turnus. Did you wish to take any, well, Ms. Heiss, let's go back to you for a second. This is our initial disposition on petition 1 from Mr. Turnus.
Yes, Your Honor. I have visited with the children and I have more visits scheduled. Mother is coming in tomorrow for a court hearing, and children have moved placements. The older two have moved placements, so I'm looking forward to meeting with those folks. And the youngest one is all their needs are being met in their current placements, and I recommend we continue pending reunification. Thank you.
Witness testimony today, Ms. Thomas?
Thank you, Your Honor. I'll call Ms. Smith at this time.
Thank
you. Ms. Smith, today, well, not today, but for the hearing on 9:30, you prepared a very thorough court report for that hearing. Are there any updates or modifications that need to be made to it since you've filed that packet?
Just a few. Since that was submitted, Jarrell has relocated to Jackson. He is, to my knowledge, no longer employed. And a referral was then made to Lifeways for him to start services in the Jackson area. And then, yes, the DNA test, he was unable to make that appointment, so that has been rescheduled until the November 22nd date.
Okay. As it relates to the court report, the case service plan, were you able to meet with Mr. Turnus to develop that with him?
Yes, I was.
Okay. And was he able to provide any input as to whether he thought the services or the plan was adequate, or if he needed additional services?
Yes, he did.
Wonderful. And do you believe that the case service plan as proposed adequately addresses the conditions that cause the children to come into care?
Yes, I do.
And as it stands today, what are the current barriers to reunification with Mr. Turnus?
Homelessness, financial stability, transportation, lack of parenting education, developmental, age-appropriate milestones, domestic violence and anger management.
Okay. You are breaking up just a little bit, so I just kind of want to give you a heads up on that, okay?
Sorry, yes.
Okay. And during this period before today, has Mr. Turnus started any voluntary services to address those barriers to reunification?
Yes, he has.
And what are those services that he has started to engage with?
He has a psychological evaluation appointment scheduled. And he's willing to attend that. He has also started engaging in the foster care supportive visitation. That's a 16-week hands-on program. I believe he's completed 2 weeks of that. He did start anger management and domestic violence briefly with Michelle Palmer. He had asked before he relocated to Jackson, a different provider. He voiced that he wasn't comfortable with her. So I'm in the process of getting a new referral for the Jackson area. And then he has made an appointment with Lifeways to start the process there for mental health assessment.
And does Lifeways in Jackson also, is that the place that also assists with employment and other areas?
Yes.
Okay. And Ms. Heiss indicated that there was a change of placement since we've been in court. Can you tell us a little bit more about that?
Yes. So the initial foster home that the two older children were placed in at the time of removal had requested replacement of them early August, partially for some behavior issues that the older child had in the home, but also a combination of the boys need a lot of services. They require a significant amount of appointments, and that family just didn't feel that they were the ones that could adequately make that happen for them. So they requested replacement, and we were in the process of licensing a new foster home. So the boys went over there and spent several weekends getting to know the family, and their license was opened on the 9th of October. So the boys changed placements on that date.
And the youngest child, I know that Mr. Turns is not the legal father of that child yet, but is that child still placed in a separate home?
Yes. At this time, neither of the homes that the children are in are willing to take placement of all three. So the siblings have the visits during weekly parenting times.
Okay. And related to parenting times, what is the current plan for Mr. Turnus and parenting time?
So we just moved his Thursday visit from 9:30 to 11:30 in the Jackson office. And then he does have a visit offered to him on Mondays from 4 to 5 in the Adrian office, with us providing him with gas cards if he could.
Okay. And are you recommending any change to the parenting time plan?
No, not at this time.
And has he been exercising his parenting time?
Yes, he has.
Okay. Are there any concerns about his behaviors during parenting time?
No.
Are the children doing well when they visit?
Yes, they are. They're excited to see Dad.
Okay. I know that you've included a lot of reports regarding the children. Well, one, I want to thank you for including the DNA for the two boys and also those AOPs. Is there anything from like the bonding assessment or any of the evaluations that you've included that you'd like to highlight for the court?
As it relates to Jarrell, no. Like I said, both of the boys have a lot of needs and require a lot of additional services. And then at the most recent, and I don't think that was included in my court report because it did just take place, I believe, a couple weeks ago, but the younger child, NT, is possibly going to be evaluated for autism. There's some suspicions at his last well-child appointment. But they did just begin services at Trenton Hills Learning Center, and those take place on Tuesdays and Thursdays from 1:30 to 3. They're working with OT, PT, speech, and special education there.
And has Mr. Turnus provided like updates on all those educational appointments or?
Yes,
I don't mean to call it schooling, but this program that they're in.
Yes, well, so the actual services just started. It took a while to get there because they were assessed at Ivy, and then because of all of the appointments that they were required to attend, I had suggested early on, because they will come into the foster home or to the daycare or to parenting times and work with the family. So then it just took a while to get the services actually started. So those services just started last week, taking place on Tuesdays and Thursdays. And then both parents have been provided with copies of all of their assessments, evals, recommendations. And I did provide them with a list of all of their upcoming medical, dental appointments and mental health appointments.
Wonderful. Thank you for that. Is there anything else you'd like to state for the record?
No, not at this time.
Okay, thank you. With that, Your Honor, I have no further questions of Ms. Smith.
All right, I have a number of exhibits that were provided in anticipation of our last couple of hearings, but I don't know if they were been addressed for admission into evidence. Ms. Kristen Smith did reference her court report. There's DNA test reports for the oldest two children concerned by petition 1. The AOPs for both of those kids, CTAC bonding assessments, IV rehab speech and occupational therapy evaluation for both kids, LASD evaluations for both kids, some referrals for the mother, and a couple of referrals for the father, and then of course the place for change notices that I was able to review today. What, if any of those, am I supposed to receive or not? Maybe none? What's the plan this time?
Sorry, Your Honor. Yes, I would ask the court to receive the court report and all of the attachments that Ms. Smith has provided. And just to cover our bases, both boys did have speech and occupational evaluations from IV rehab, and then also N, the child with the initials NT, had a physical therapy evaluation there. And those reports are included, and I would ask the court to receive them. Thank you.
They're included, where are they included?
Just part of the court report. In addition to the ones that you noted, there's also a physical therapy eval. That's all.
Let me see if I have that. This is what I'm worried about.
Sounds like L&M maybe is what the NT child had physical therapy and speech assessments.
And occupational.
Yeah, so that'd be KL&M.
I have, it looks like there's some reference to those things in the LASD read reports. And I do have the IV rehab speech and occupational therapy evaluation for both P and N. Is that what you're talking about?
There's I don't know if you are reading it through a PDF reader, but on page 61 of the packet. No, okay.
I've got the physical.
Okay. It would be Exhibit L. It's marked as Exhibit L. It's maybe about halfway through the packet. I just want to ensure that we all have that, the physical therapy initial evaluation.
Is it from IV rehab?
Yes.
Then I do have it, yes. Okay. Any objection, Mr. Brooks?
I'm looking.
I have a list of approximately.
I'm looking at this page 61. What's it supposed to tell me?
Ms. Hummus, did you want to take that one?
Yeah, that was just the physical therapy initial evaluation.
Oh, what I have is strictly a physical evaluation, so I'm going to assume I've got it, and I'll look again after this hearing. I have no objection.
Very good. We have a mom's initial disposition scheduled for tomorrow, so I was going to leave it open for objections, understanding that many of these documents also concern Angel Rosas. So I can leave that open to you, Mr. Brooks. If you come up with some questions or your client gets hold of you with any issues, then we can look at those tomorrow if you wish. Or next time you come back, because I don't think you'll have to come back tomorrow, actually.
And I have received and reviewed all those, the court report and all those attachments, have no objection to the court accepting them as exhibits. Thank you.
All right, they're received. Questions of this witness, Mr. Brooks?
You reference domestic violence with regard to my client. Has there been any police reports substantiating domestic violence?
I have not seen the police reports. Mr. Turnus has in conversation when he completed, we call it the bio-parent interview, had explained that there was some significant domestic violence within the home between him and Ms. Rosas.
Thank you. Would you describe Mr. Turnus as cooperative or resistant to services that you're offering?
He's been cooperative.
I have nothing further.
Okay. Is there any arrangements or opening made for Mr. Turnus to have unsupervised parenting time? Or what if any, are your concerns around that? At this time,
there wouldn't be not only a location for him to have the unsupervised parenting time, but I still think that we have some concerns as far as the lack of knowledge when it comes to age appropriate milestones, expectations.
All right. Questions, based on my questions, counselors?
Just briefly, Ms. Smith, I'm not able to locate quickly, but do you have a proof of service that shows that this father got this court report?
I do not have the proof of service. I can look it up. I mean, I don't have the proof of service with me now, but I handed it to Jarrell during a parenting time.
Oh, you did? You gave it to him by piece of paper?
Yes, I handed it to him prior to this.
Good. Okay, thank you very much. I have no other questions. Thank you.
You said there are other considerations to granting him unsupervised visitation, but you didn't specify what they were. What are they?
I'm sorry, can you repeat the question?
You were asked, not by me, but by someone else, I think it was the judge, what consideration's been given to unsupervised visitation with Mr. Turnus? And you said there are considerations involved there where you don't think he's ready for unsupervised visitation. Do you remember saying that?
Yes,
No?
I remember. I remember saying that. At this time, I don't think that Mr. Turnus is in a position to have unsupervised parenting time, as he recently relocated and is residing in maybe a shelter in Jackson. So we would have to discuss where these visits were taking place to make sure that all 3 children would be safe. He has voiced several concerns of somebody in Adrian harassing him, and he's scared for his own safety.
I see. That's all. Thank you, Your Honor.
Anyone else you'd like us to hear from, Ms. Thomas?
Not at this time, Your Honor. Thank you.
Mr. Brooks?
Mr. Turnus, do you have anything you want to say?
He's come in by phone and I had to mute him because there was some noise, so I'm asking him to unmute on his end.
Is he still on the line?
He is, but he's muted, and sometimes it can be tricky to unmute by phone, so give him a second.
Well, other than that, I have no witnesses. And I don't even know if he wants to testify.
All right, Ms. Heiss?
Your Honor, I have no witnesses today.
Thank you. All right, it would appear Mr. Turnus is not able to unmute on his end. Mr. Turnus, if you can hear me, I would encourage you to reach out to your attorney if you do have any questions or if you wish to be heard, and I would be happy to make those arrangements. Oh, we got it. Mr. Turnus, can you hear me? This is Judge Sala.
Yes, I can hear you.
Mr. Brooks?
Can you hear me?
Sir, I'm your attorney. Do you want to testify?
No, sir.
Thank you.
Okay,
And I have no witnesses, Your Honor.
thank you. All right, thank you, Mr. Turnus. Well, the court, all right, closing comments. All right, I got ahead of myself.
Okay, Your Honor. At this time, Judge, we are asking the court to adopt the case service plan and enter that into an order as relates to Mr. Turnus. For parenting time, we are requesting continued supervised parenting time. It is still fairly early on in the case services and trying to gauge his compliance with and benefit from those. Dad did enter a plea back in August indicating that the children did not receive adequate medical attention and that he needed to continue to build some parenting skills. And so I think with that, there definitely needs to be a time where he can have that support and be given that education around parenting. And he had a pretty favorable bonding assessment with the children. And so I think that lays a strong foundation moving forward. But for the time being, it seems that the children would be most protected by a supervised parenting time schedule. And then with that, Your Honor, we would just request a 90-day review, at which point we're hopeful to have the DNA back for the youngest child. Thank you.
Mr. Brooks.
I have no closing and I have a hearing that's scheduled 1 minute ago on the 3rd floor. May I be excused?
If you want to give me just a couple more minutes, I think I can get my remarks done. Ms. Heiss?
Your Honor, I do still have concerns for unsupervised visits. For example, when a child falls down and doesn't cry, a father may think that that's very heroic, but I think that, and I did see this in a visit, that a high pain tolerance or a not understanding that an adult is someone who cares and someone that you can go to is an important distinction for this dad, and he'll learn that through parent education. In the developmental stages, information will give that to him. The CTAC shows strengths for the father, and I have seen strengths in the visits. He knows about nutrition, and it was nice to see him doing that. So I would ask you to not allow unsupervised visits, but to set us a review in 90 days.
Thank you. The court finds all interested parties were given notice for purposes of today's initial disposition hearing. I have reviewed the case services plan. It does appear to target the areas that Mr. Turnus needs to work on in order to secure the return of his children safely into his care. The issues have been identified, as well as the issues around supervised versus unsupervised visitation. I would remark, I think I agree with Ms. Heiss on her remarks, but also as it relates to some of the concerns expressed by our caseworker, in that Mr. Turnus appears at times to be concerned for his own safety. There's concern about where his parenting time would be taking place. And although we do have some good building blocks in the CTAC assessment, that he does need to continue building on parenting skills as well, consistent with what Ms. Heiss has shared with us. So for those reasons, he will have the supervised parenting time, as always, in place, and that is spearheaded by our caseworker. I also find she is in satisfaction of her obligations to provide reasonable efforts. I'm adjourning the pretrial to be heard with our next review. The pretrial is on petition 2. That will be adjourned to January 13th at 10 o'clock, which will be Mr. Turnus's next review as well.
January 30th at 10.
13th.
Pardon me?
January 13th. 1-3
1-3.
at 10 a.m. In the meantime, the children will remain in their placement. That is the safest and least restrictive, as Mr. Turnus works on housing, employment, parenting skills, some mental health services, and some of the other things that were mentioned. There still remains a risk of harm associated with returning him to his care, and I look forward to the updates on January 13th at 10 a.m. Unless there's any questions, that's all for today.
Thank you.
Thank you, Honor.
Thank you, Mr. Brooks. You may be dismissed. All right, we are back on record. We were on record on this one yesterday to look at the case as far as what's been happening with the father of the children. And today is the date and time set for the initial disposition as it relates to Angel Rosas, the mother of the children, on petitions 1 and 2. Just to update you, which I'm sure your attorney may have already done so, we did have a number of exhibits that were reviewed yesterday and are pending. Well, they were received, but you'd be welcome to make any objections that you needed to. I know that these exhibits have been served and been in the possession of all of the attorneys and the parties for some time, but I'm happy to listen to any objections on this today.
No objection. I have reviewed those yet.
Oh, thank you. Appreciate it. All right, so those will become part of our file. So I look forward to the rest of the proceedings as it relates to the disposition after appearance.
Lee Heiss, lawyer guarding the light.
Good
Michael
morning, Your Honor.
McFarland.
Oh.
Sorry. Go ahead.
Sorry. Ms. Saja Thomas, counsel for the department. Ms. Smith.
Kristen Smith, foster care worker, Catholic Charities.
Michael McFarland, representing mother. Please introduce yourself.
Angel Rosas.
She's feeling ill today, so she's wearing a mask. I asked her to speak up just a little bit, Your Honor.
Yes, I can hear her. Thank you for that. Ms. Heiss.
Thank you, Your Honor. I visited with the children. One child's placed outside of Lenawee County, and I Zoomed with her this time and met with the other 2 children face to face. As an outsider to the family, I'm really struck by the children. They've been kind of deadpan. I've seen them in visits with mom and dad. I've seen them at the other placement. They're at a new placement now. I didn't know they had dimples. They are smiling. They've softened. I really hope that while we're working on reunification, mother will look to what's going on for the kids and try to imitate it when they come back home, because it is, when they're in a healthy environment, it really shows. I didn't think these kids had the ability to communicate in receptive language and expressive language, but they certainly do. So placements are meeting all the children's needs, and I think the case service plan will, when mom succeeds at all the pieces laid out for her, she will be in the best position to take the children back. Thank you.
Ms. Thomas?
Thank you, Honor. If Ms. Smith can be sworn in, please.
James?
I know we were here yesterday, but just briefly as it relates to Mom. The court report that you filed for the September 30th hearing date, are there any updates or modifications that you need to make to it as it relates to Ms. Rosas?
Yes, I do have a decent amount of updates actually. And I'll kind of just go down the list of how it was laid out in the court report. So regarding her employment, I contacted Little Caesars because she had not verified employment with the agency by a pay stub. And I was informed that she stopped showing up and that she was only employed there for about a week. So at this time, I am unaware of her employment status if she obtained new employment. Regarding transportation and housing, the agency did provide Ms. Rosas with a new bike as well as a bike lock. Unfortunately, since the day that we provided it to her, we have not seen it. We're able to provide her with gas cards and Runaway transportation assistance. But other than that, I'm not sure what her status is with transportation. Housing, Ms. Rosas still refuses to provide the agency with an address. She reports that she's staying with a friend, but that friend, what it sounds like, does not want keep in foster care in the residence. Adrian Counseling and Psych, I had made a referral for her for a psychiatric evaluation and provided her with all of the intake paperwork. To date, Ms. Rosas has not scheduled that appointment or attended. I followed up with Michelle Palmer regarding anger management. She contacted me yesterday and said that Ms. Rosa scheduled an appointment with her on the 30th, which she did not attend. It was a no-show, no-call. She hasn't heard from her since to reschedule. Parenting times. She had 2 no-call, no-shows to her parenting time. So after that, the agency had asked and required her to confirm 2 hours prior to her visit, given the distance that one of the foster parents travels with the youngest child. And then Ms. Rosas, again today, failed to confirm that visit time. So right now she has 2 unexcused visits with the foster care supportive visitation program through court. I do know at 4 they will discharge the program.
You're cutting in and out, Ms. Smith. Can you repeat that, please? I only got about every other word of that last bit.
Yes, sorry. I can, maybe if I shut my camera off, I might have a better connection.
I think if you just make sure you're close enough to the microphone, that should resolve it.
Okay. Regarding the foster care supportive visitation program that she's currently engaged with, she had 2 no-show, no-calls. And given the distance that one of the foster parents commutes with the youngest child, we had asked that, and it is a morning visit, we asked that Ms. Rosas confirm 2 hours prior to that visit. I do know that today was another missed visit because she had failed to confirm on time. With that program, they only allow 4 unexcused visits, and right now she's at 2. So it's hopeful that we won't get to that point. And then for parenting times, Ms. Rosas, generally the visits that she does come to, she is on time. And at times she's prepared, other times she lacks the necessary items for the children. Most importantly, appropriate food. I know that it's been discussed several times and she's been encouraged and other items have been suggested by myself, our other staff members, and the early Head Start worker that was working with her. Unfortunately, Ms. Rosas becomes very upset and argumentative and dismissive with staff and doesn't appear to want that help or suggestions. So sometimes visits are difficult.
Thank you for those updates.
Yeah.
As it relates to the case service plan, well, let me just ensure that reunification is the goal for Ms. Rosas and the children at this time, correct?
Correct.
And as part of reunification, a case service plan is developed and you have prepared that and submitted it. Did you have an opportunity to formulate that with the input of Ms. Rosas?
Yes, I did.
Okay. And were there any other services that she has brought to your attention she may benefit from?
No, not at this time.
And currently, what are the barriers to reunification for the children to go home with Ms. Rosas?
Appropriate housing, financial stability, untreated or undiagnosed mental health issues, and an overall lack of appropriate discipline techniques, knowledge, developmental milestones, and appropriate nutrition for the children.
And it sounds like, so prior to today, she was not court ordered into any services, but it sounds like there has been some participation in voluntary services. Is that fair to say?
Yes.
Okay. And I know you just went through all those updates, but what are some of the voluntary services that mom has started to participate in?
She initially attended, I believe, 3 sessions for anger management. She was scheduled for the psych eval in September. She unfortunately missed that appointment. That has since been rescheduled to December. And it's my understanding that she's planning on attending that appointment. Richards.
What is the current parenting time schedule for Ms. Rosas?
She visits on Mondays from 3 to 4 p.m. and then on Tuesdays from 9 a.m. to 11.
And is that with all 3 children?
Yes,
both of
it
those times?
Yes.
Okay. Is there anything from your report that we missed that you would like to highlight on?
No.
And just to ensure we have a complete record, yesterday we discussed all of the children's medical needs. And I just want to confirm that you are also providing mom with copies of any assessments or evaluations, and that she's informed and or included in any of those appointments.
Yes, she has received copies from the IV rehab assessments as well as everything that was completed with early on. And then when I provided her with a copy of this court report, she was also provided a list of their upcoming medical, dental appointments, and mental health appointments from now until February.
Okay, thank you. With that, Your Honor, I have no further questions for Ms. Smith.
Cross-examination, Mr. McFarland.
My client informs me that she appreciates the bike you purchased for her, but it now has a flat tire. Is there a way that we can get the tire fixed for her so she can go out and look for a job and other places to live?
Yeah, when I provided her with the bike, I had explained to her that it was in our agency's garage, and that the tire was low, that she just needed to put air into it. So if she would like to bring the bike here, we can put some air in it for her.
Well, I mean, it seems you gave her a bike with a defective tire. Is there any way you can give her a bike with a tire that actually works? She doesn't have a pump. How do you bring a bike with no pressure that's going to be flat every day? I mean, how do you expect her to use that?
To my knowledge, there's nothing. It was a brand new bike, because it had been sitting in the garage with the cold season last year. It just deflated. To my knowledge, all she needs to do is put air in the tire. If she needs assistance with that, I can help her put air in the tire.
Okay, she tells me it has a nail in it now, is what happened. So where would she take it to get it repaired? Will your agency do that at that garage? I'm not familiar with that.
If she can bring the bike to the agency, we can assist her, yes.
Okay. Priorities. I know there's an awful lot that she needs to do. Well, how would you prioritize what she should do on her case service plan?
At this time, I think that for Ms. Rosas, it's important, her mental health at this time. It was noted in prior reports that she may have some mental health diagnosis. I think that in order for her to be at a stable place for herself and her children, that would be the first thing that she needs to work on. So that would be contacting the Adrian Counseling and Psych to set up that intake appointment, as well as attending her psychological evaluation with Dr. Haugen in December.
Where is that scheduled for? Where's his office?
That is in Hillsdale, and the agency provided her with a $25 gas card for the last appointment. However, she reported that that was stolen. Since I have told her that I will give her the gas card the week of that appointment. So that's a conversation that her and I have had.
Okay. My understanding is that there may not be Section 8 housing available right now, but is that something that she would go through her worker to attempt to at least pre-qualify for Section 8 housing?
Yes, we've discussed that. I think that there's an issue because of having an eviction on her record. And when I had asked her last about her housing, she said that she was residing with a friend and that she could stay there and the children could stay there. However, she won't provide me with that address in order for the agency to assess that home.
Okay. And if her opinion now is that it's not a good place for the children, what can we do to assist her with housing if she may not qualify for Section 8?
Honestly, I'm with evictions on her record. I'm not sure the specifics of what qualifications there are. I don't know if that would necessarily, I don't know if she would be approved for that given the evictions on her record. I think that it has to be within a year or 12 months.
Right. I understand that. I'm going under the presumption that you're correct that she may not qualify for Section 8. What assistance then can the agency actually do for her? Help herself get housing?
For right now, we could assist her with local shelters. I know that she had stayed with Catherine Cobb. I don't know if she can return there after her 90-day stay was up. But I would encourage Ms. Rosas to obtain sufficient employment. And then we could help her look for apartments or housing.
And right now, my understanding is the parenting time is how often per week?
Twice a week.
And the duration is what, 2 hours?
1 hour on Monday and 2 hours on Tuesday.
So 3 hours. If she consistently keeps that parenting time, would you be willing to consider expanding it to what's typically the norm of 3 visits, 2 hours per week?
We could discuss, increasing visits. That's always our plan as the parents, progress and as, the case is, going well and she's available. I will say that the amount of services that the children are in and the location of the children.
Hang on, sorry. Are you okay? That's okay. Right, you just get up and walk out if you need to. Oh, so sorry. All right, she's still upright, in case you're wondering. She's
Okay.
all right. Bit of a cough. If it gets worse, we're all abandoning ship over here, but she says we don't have to at the moment. Okay, go ahead whenever you're ready.
Okay. So yes, the agency would be open to exploring expanding parenting time. I will say not only the services that the boys are involved in keeps them very busy, as well as some of the concerns that the agency does have during parenting times. They are also, it was noted in the bonding assessment, Ms. Rosa's struggles to manage her time between the 2 children, now with the addition of the youngest child. So at this time, the agency would not be increasing parenting time until some of those issues were resolved.
Do you think maybe a combination of visits between the children when she can maybe start to focus more time on some of the kids might be, if she thinks that's good, do you think that might be explored?
To stagger visits or split? Is that what you're asking?
Yes, exactly.
So, honestly, we kind of do that because the agency has to provide transportation for the children for the visits. And our company vehicle is not able to fit all three of them. So when we transport the two older children back to daycare, we offer both the parents that half an hour to stay with the baby, and have that one-on-one time with them. It's
Okay.
hidden. Sometimes the parents choose to stay, sometimes they choose to leave. And then when the boys are also dropped off, they get here early. So I've let Miss Roses know, and she has come 15 minutes early, that she can spend that time with the boys before the baby arrives. So we kind of already do that. Obviously, when the children are returned to her care, she's going to be responsible for caring for all three of them.
Did I hear you say that Ms. Rosas has turned down an opportunity to have more parenting time? Is that what I'm hearing?
She has. It's not very frequent, but there have been times that, we've had the baby in the office waiting for our case aide to come back, and that she had chose to leave instead of to stay with her. So then a staff member will just stay with the baby.
I think that's all the questions I have.
Very nice.
Have one moment. Anything else you want me to ask? Further.
Ms. Hicks.
Ms. Smith, has the mother received the court report in paper or email? How did she receive it?
She received it in person. I gave her a paper copy at one of the parenting times.
Would you consider, when the next court report is drafted, maybe scheduling an appointment so we can all, I want to make sure she's really working through the court report and reading it all. And if there's any barriers that we're spoon feeding her, would you be open to that?
I guess, what are you asking? I'm sorry. Could you clarify what exactly you're asking?
Well, in the end, I need to make an evaluation what's in the best interest of the children. And before I evaluate mom's response to the court report, I want to know that she's had an opportunity to read it and really ask questions and get through the whole thing before I hold her accountable for it. You know what I mean?
Yes.
So I would ask that maybe a family team meeting be set so I can observe you going through it with her, observe that her questions were answered and all that kind of stuff.
Yes. And in addition to the court report, we also, as case managers, we generate case service plans in a different, through the state system. So we review the parent agency treatment plan and a case service plan in a different format with the parents every 90 days. And normally when I like to kill two birds with one stone. So I normally do that before a parenting time. So I can always get with you and let you know when I have the case service plan that I'm going to review with the parents. And if you want to, you could come observe that and then stay for the parenting time if you needed to see that as well.
That would be really good, because what I'm noticing, mom didn't attend the OT, PT, or speech evaluations for the children, did she?
No.
And was she made aware of those appointments?
The ones at Ivy Rehab, I don't believe so. I think those were scheduled with the foster parents. But the ones with all of the same assessments that were done through early on, we actually scheduled that to take place in our office, and both of the parents that they were no call, no shows to that visit. Okay. So that assessment was actually, those assessments took place in our office during one of the parenting times.
In the court report, I see that you've texted mom so that she's aware of the date, November 4th at 2 p.m. for her psychological evaluation, correct?
Correct.
Okay, I have nothing further. Thank you.
Any redirect?
I have none, Your Honor.
Any recross?
No, thank you.
Thank you for your testimony. Any other witnesses today, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
I'd like to call my client.
Come on up to our witness stand. Ms. Melissa?
First of all, I want to address, I know I've discussed this with you, but the question the guardian ad litem is asking is that, were you able to read and understand the case service plan and the court report that was prepared for today?
Some of it.
What are the barriers to you? Do you have difficulty reading or comprehending, or what does some of it mean?
Comprehending it for me.
Okay. Have you been diagnosed with any type of comprehension issues?
Yes.
What?
It's hard for me to read a little bit, hard for me to understand some things.
Have the doctors said there's a specific diagnosis that you're aware of?
No, not really. I remember what I used to take for medicines a lot.
Well, give us an idea.
ADHD medicine,
Okay.
anxiety medicine, sleeping medicine to make me go to sleep.
What's the highest degree of education you've completed?
11th.
11th grade. Would you say you had difficulty reading while you were in school?
Yes, sir.
Okay, so like the guardian ad litem, but I also want to know is what can be done? Can you stop if there's a word you don't understand and say, can you tell me what that word means? Would that be helpful to you?
Yes,
Are simple words easier than complicated words?
sometimes.
This is your roadmap, as I explained to you, to get the kids back, close the case and reunify. So we want you to understand what it is. When I ask you, did you get the case service plan, and you understand it? If you don't understand it, rather than saying, yes, I need to know that you don't understand it, okay?
Yes, sir.
Okay, so would you like the worker and the guardian ad litem to go over the case service plan with you so you understand it as she's suggesting?
Yes.
Okay. Is it true, as I told the court, that your tire now has a flat tire from a nail or something?
Yes.
Okay. Can you get your bike back there so they can fix it for you?
Yes.
What happened with your job?
It was too far and I didn't want to keep going to it. I was looking for a job a little closer, somewhere in town. I tried the library, Taco Bell. I tried a restaurant that's kind of just opening up, but they said they're not looking for anybody right now.
Now, housing, is it true that at this point in time, you don't think that's a suitable place for kids to be with you?
No, not right where I'm at, no.
Okay. Because the agency would like to check it out to see if kids could visit you there, but you're saying right now, you don't think that would be appropriate. Is that what I'm hearing?
Yes.
Okay. You also told me that sometimes you don't have access to charge your phone while you're there. You sometimes miss appointments because you have no alarm, right? I discussed with you the possibility of maybe going down to Salvation Army and trying to find up a wind-up clock, and if the worker happens to run across one, you could use that. Is that what I'm hearing?
Yes, sir.
The old-fashioned one. Okay. You heard the worker state that they've offered you extra time and you've turned that down. Can you maybe explain that?
No. They've never asked me to stay. Every time it's visits over, I either, like on Mondays, the parents are here to pick up the daughter and I have to help the boys go. They never asked me to stay with my daughter a little longer. If they would, I would. I wouldn't turn down any more time.
And the first missed psychiatric evaluation, what was the reason that you missed that?
She said she was gonna give me the guest card prior to the visit. We kind of talked about it, but then never exchanged that guest card, so I missed that visit. But this one I won't miss.
She said that you told her your gas card was stolen.
Yes, the first one did, and she said she was gonna provide me another one to get there, but I told her to hang on to it until it was time for me to go. Like,
Did you do this by texting her?
no, we talked over the phone that day.
Okay. Where do you think you need the most help right now?
Housing. I would say housing.
Are you welcome back at the shelter?
I would think, yes.
I mean, have you asked?
No,
I mean, I see them in court here. So have you chatted with them at all?
no,
Do you want to go back to the shelter on a temporary visit? Let me just ask you that.
I don't know.
Fair enough. Fair enough. I know it's gonna get colder here. I'll probably stop by my bike to work shortly. What about you? Are you gonna be able to ride your bike to get places?
I'm still gonna do it.
Okay, okay.
Just get a dress warm.
Gotcha. Okay. Take down their advice. Anything else that, well, it sounds as though they want you when you come to visit. Now that you've heard it, you haven't been ordered yet, but they would like you to bring suitable snacks.
Just last
Just listen to me, okay? They would like you to bring suitable, healthy snacks. Looks like suitable things for kids to do. And if you've done it in the past, good, but do you hear what they're asking you to do in the future?
Yes.
Is that something? Can you bring these things on your bike? Do you have a backpack or anything to carry?
I bring a backpack full of stuff with them.
Understand you might not qualify for Section 8 because you've had a prior eviction that you still owe money on. Is that true?
Yes,
Is that here in Lenawee County?
yes,
It sounds as though they think getting a job, getting some financial independence is your first step. Do you agree with that?
yes,
If you think you need help trying to get job access to the library or the internet or places to look for a job, do you think you need any help getting a job?
yes.
Okay. You understand why the psychiatric evaluation is important, because if you had these diagnoses as a child, that maybe you still need to have some medications or treatment for these things as an adult. I don't know, but you understand that that's one reason for that.
Yes,
Okay. You have access to healthcare right now?
yes. I got Blue Cross.
Okay. Yeah, I think we talked, you have access to food right now? Is that yes?
Yes, sir.
Okay. Anything else that you think that we can do for you to make this a success for getting your kids back?
Just help with housing. That's the main goal right now.
It sounds like also help you understand all these important documents that you get, right?
Yes, sir.
Yeah, you have my phone number, you know my office is, you've been there also, right?
Yes, sir.
Okay. Anything else? Okay, sorry you're not feeling well today. We'll see if anybody else has questions for you.
Ms. Thomas?
Mr. Rosas, is there a reason that you have not contacted Ms. Smith about your bike?
I told her over a conversation about it. She asked about my bike and I told her that it's got a nail in it and she didn't say nothing about it. She kind of rolled her eyes and didn't say nothing.
And you also stated that she's not giving you gas cards,
Yes,
but she testified she did give you one and then you told her it was stolen. Is that correct?
that was the first one. Yes. The second one, she was supposed to give to me when it got closer to me to go to that doctor's appointment. We discussed about it, but she never gave it to me when it came time for me to go to that.
So what was the first gas card for?
For that appointment? I was at the shelter at that time and I didn't know I couldn't leave it where I had it and somebody took it from me.
Okay. Where in, you don't need to give the address, but where at is it that you are staying? What part of town?
Downtown.
Okay. And Little Caesars is on Maumee Street. Is that where you were working?
Yes. Yes.
And your reasoning or your excuse for not keeping that employment was it was too far?
Yes.
And from the courthouse to Little Caesars, it's a 1.9 mile route. And on a bike, it takes 11 minutes, according to Google Maps. That's too far for you?
I would challenge that it takes 11 minutes by bicycle, but anyway.
Or less.
Or less, I would. Yeah, I've ridden up the country market from downtown. It's longer, but anyway. It's all uphill also.
Noted.
The coast back is easy.
Is that too far for you?
I have a different question.
No,
Sorry,
I can
what was it
answer.
this
If 1.9 miles on a bike is too far for her.
A little bit.
How motivated are you to get your kids back?
A lot.
Okay, but not 1.9 miles motivated.
Objection, argumentative, Your Honor.
Ms. Thomas, did you want to respond?
It's a direct question. It's not I'm not asking a conclusory question or making an argument with it.
Ask and answer.
I think you've made your point. Yeah, thank you.
Move on. And Ms. Rosas, Mr. McFarland asked that it's getting colder out and, maybe a bike's not appropriate. Has Ms. Smith also given you transportation tokens for Lenawee transportation?
Yes. but not
And have you
recently.
utilized those?
Yes, I already have.
And have you contacted Ms. Smith to let her know if you need more?
No, because she gave me a bike, and I was using that until I got a flat tire.
And for parenting time, the no call, no shows, what were the, I'm sorry if you've already answered this, but I missed it in my notes. What were the barriers to showing up to those parenting times?
One, I was sick on some of them, and some of them I forgot to text her. My phone wasn't really working. I don't know what else to do when my phone's not working.
In general, how do you stay organized to keep track of appointments?
I have them set on my phone calendar, reminders, and sometimes I write them down.
What happened with the anger management with Michelle Palmer?
That's actually, I have been going. I've been seeing her every Monday. You can even talk to her. I talked to her yesterday, over the phone. We've been doing our sessions. And we're also gonna meet next week on Monday. And I did miss one Monday when we had court, and I told her the reason why I missed it. It's because I was still in court. And we rescheduled that one.
The supportive visitation program, are you finding that beneficial at this time?
A little bit.
What does that mean? A little bit.
Cause y'all don't really, I mean, during the visits, when y'all had the early on and then the parenting, like when I first did the session with them, they didn't really teach me anything, didn't tell me anything. They just sat back and watched, but didn't say anything the whole entire visit. Wendy, on the other hand, she gets hands-on. She shows me right from wrong. She tells me. She gets in, she interacts.
Okay.
The other people, they don't. They just sit back and just watch. You want me to learn, you gotta teach me. You want me to learn, you gotta teach me. Be hands-on.
So okay, so supportive visitation is not as hands-on as you would prefer.
Yes.
Okay.
And I'm no longer seeing Wendy no more. I don't know what y'all really want from me. Y'all want me to be hands-on. Y'all don't really teach me what y'all want me to learn, or what y'all want me to, or to expect me to learn from you guys.
Ms. Rosas, I just received an email from indicating from Ms. Palmer that she did not hear from you from 9:30 until, well, September 30th until October 11th. Is that true?
I got messages in my phone. My phone's over there. If I can get it.
Just, no, just answer the
Okay.
question if you don't answer.
I don't remember those dates, but maybe. I don't know. We've been
And-
talking for a minute.
And you said that you spoke yesterday, correct?
Yes.
And you said you scheduled an appointment?
Yes.
So you did not tell her that you have court in the morning, a jury trial, and that you would not be able to schedule an appointment until after the trial?
No, I told her we'll meet on a Monday. She said that was fine.
I have no further questions,
That's it.
Jenna.
Ms. Heiss, any questions?
Thank you. Are you still using Catherine Cobb's support and training about domestic violence?
No.
You don't talk with them very much anymore?
Not really.
Okay, so if we were to meet before the next court hearing and go over your court report with you and answer any questions, who would be your support person that you would like to bring to that meeting?
That would be Roxy.
Is that your aunt?
Yes.
Now, how often are you in contact with her?
A lot. I mean,
How about your mom? Are you in contact with her?
yes.
How often?
Often.
Okay, so are you using those or any family supports for transportation?
Yes. Right now, my mom's van's not working at the moment. She needs to get, or something's wrong with the engine. She needs to get something fixed with the engine.
But Roxy takes you places?
Right now, her car is not available either.
Okay, so what do your family resources help you with?
They just help with a lot of things. I can't really like pinpoint.
Okay, how about your court report? Where is that pack of paper?
It's in one of my backpacks.
Have you shared that with your family?
No.
Okay, do you want their support in this case?
Yes.
All right, so you use THC.
Yes.
How is that helping you comprehend like the court report and that kind of thing?
Can you be more specific?
No. Using THC, what is that helping you with in life? Why are you using it?
Okay. Why do you like drinking water?
It's as basic for you as water?
I mean, why? I can stop whenever I want. It's not the fact that I want to do it. It's
addiction, maybe?
It's not an addiction. Because if I was addicted to it, my levels would be off top. My levels aren't off top now.
How do you know what your levels are?
Because y'all drug test me every other week, every other 2 weeks.
Okay, and then well, we're trying to teach you what we want you to learn, right? So we're looking at what the barriers are for you to learn. Do you think THC is a barrier to you learning?
No, it's not.
What are the barriers to you learning?
I learn at my own pace. I don't learn how you learn. I'm not like you.
Right, but how long will it take you to learn?
Not that long.
Like a month? The kids have been in care 4 months. What was it that Wendy helped you learn?
How to interact with my kids.
Yeah. Can you tell me one thing that you do differently now? Because Wendy was, you say, interactive and really show you what we need you to learn. What did you learn from Wendy?
How to try to give them my time all at once and do it the right way instead of trying to overwhelm myself. And
yeah, that makes sense. That's exactly what we're hoping, that you can tell us what it is that you learned. So have you learned anything about nutrition yet? What to feed the children?
Yes. I brought waffles, bacon, and some eggs last visit. Well, strawberry waffles. They were little though, but they loved them.
Just plain?
They had some syrup on them, but not that much syrup.
Okay. Are you aware that nutrition is something we're hoping you'll learn about?
Yes.
Okay. And then how do you think your kids are doing?
Now that they're in a different home, I'm noticing different things, that they're more happier where they are now than they were where they were.
Okay. And the little girl is in the same placement, correct?
Yeah.
You are aware that this case is going to run for a certain amount of time, right? And then, so we're trying to help you get this done on time to be reunified with the children. And we're 4 months in. How do you, if you were to give yourself a grade on how much you've done to get your reunification? Would you give yourself an A, a B, a C?
B minus.
Okay, what do you think the agency, when they assess your progress, what grade would they give you right now?
Maybe a C.
Okay, all right. Okay, thank you, Your Honor. I have no further questions.
Mr. McFarland, any follow-up?
Just a couple. This Wendy you're mentioning did a good job with you. Who is she with?
Early on,
Okay. Would you like to see if they could possibly employ her to assist you?
yes. Yes, sir.
Or at least somebody who's actually hands-on and talking? Is that your clearest way of learning? Is it by reading? Is it by watching videos? Is it by having somebody talk to you? What's the best way that you can learn?
A little bit of all three. Hands-on, videos, reading, just a little bit of mixture of all three.
Well, I know you told us that you do have some problems reading. Do you have any problems with the English language?
No, sometimes I'm dyslexic.
Dyslexic, perhaps? Were you diagnosed with that as a child?
Yes.
Okay, okay. So what does it take? Somebody to read it to you?
Sometimes.
Okay, fair enough. And this is what we need to know today so you can be successful. Also seems perhaps maybe what was being asked of you is you're using marijuana for recreational purposes, right?
Yes, sir.
And they're kind of wondering if that money couldn't be put aside in a bank account rather than for yourself, for the kids. What are your thoughts on that?
Well, if you put it that way, they could have just said it that way instead of.
Well, I'm asking you
The
that
other
way.
way,
I'm
but
asking you
yes,
that way. Okay.
I understand that.
But they probably, if I thought about that, I'm sure others are thinking of that too, okay? You have some physical issues with your body, right?
Yes, sir.
Refresh my memory. What are those physical issues?
I have gallbladder issues and I have arthritis a little bit in my hands.
Do you need to go to any medical appointments in town or out of town for your gallbladder or the other?
No,
I remember you testified at the trial that
I'm like,
you're recommended to get some gallbladder treatments, right?
yes, sir. I'm waiting for that. They said right now it's fine. Until it goes up in flames again.
Okay, that's fine. I just wanted to find out if that was something you needed transportation or help for. Okay. Think we've covered everything?
Yes, sir.
Thank you. I guess one last question. Did I hear you would like your mom and your aunt present when you meet with a worker to kind of be kind of like a live memory for you to kind of go over these things?
Yes, sir.
Okay, I have nothing else.
Any recross, Ms. Thomas?
No, Your Honor.
Ms. Heiss?
No witnesses today, thank you.
All right, thank you for your testimony. We return to your seat. Is there anyone else you wanted us to hear from, Mr. McFarland?
No, thank you.
Closing comments, Ms. Thomas?
Thank you, Your Honor. At this time, we are asking the court to adopt the case service plan into an order so that Ms. Rosas can begin working on that and we can begin monitoring or continue monitoring her progress in addressing the barriers to reunification. At this time, I'm very concerned about her truthfulness and her motivation to be reunified with her children. But I'm hopeful that as she continues to engage in services that she will be more honest and hopefully show us that she's motivated. With that, we are just asking for a 90-day review. Thank you.
Well, I know it's humbling for somebody to admit that they have learning disabilities and that she has reading comprehension problems. That it is difficult for her to ride, the distance uphill on a bike. We've heard no testimony to the contrary, that she was told she'd get another card for a psychiatric evaluation that wasn't given to her. I take it now that the agency at least knows her past diagnoses, knows that she's dyslexic, that under the American Disabilities Act, they will try to accommodate those issues with her, and that she's more of a hands-on person, that she likes to be instructed and shown physically how to do things, and told active interaction more than just an observation and a report later as far as how she was. So that's, for her, is going to be the most beneficial, and we appreciate the prioritization that will help her. So that's the last thing. My client would also like the agency to consider that perhaps some of these visits could even be supervised at her mother's house. If that could be, if her mother would allow her house to be inspected for suitability for visits. If she knows these visits are supervised, if a supervisor could be present at the visits at her mother's house, so it's in a familial setting, which is comfortable for the kid. Thank you.
Ms. Heist.
Thank you, Your Honor. I think that it's important for parents to hear and for us to be sure that we've told the parent, whether they want to hear it or not. Tell them that today is not a day for reunification, and every review period that is like today would not be a day for reunification. There has got to be progress. I look at those kids and they're doing well. Mom isn't yet doing well. And she has to do well for a long period of time for the kids to be able to go back to her and have their needs met. So as long as we're all clear and communicating so that this is no surprise, if we have more review periods where mom isn't progressing, that we're not getting where we need to go. So I just think it's fair to say that so that it doesn't seem like a surprise at the end. Thank you.
Thank you. The court finds all interested parties were given notice for the initial disposition hearing. It felt a lot like a regular review hearing today, but that's probably because the children have been removed, the older two since June, the youngest since August, which has given Ms. Rosas some time to try to get on her feet and to accomplish some of the things that she understands, I know, needs to happen. The reasonable efforts towards reunification are certainly being made. Mrs. Smith, as always, has done an excellent job documenting the services that are being offered to Ms. Rosas, perhaps to a fault. And I hate to say that because I always love reviewing all of her work. It's so detailed. But I think we might be giving you the wrong impression, Ms. Rosas. We're expecting you to get to a point where you can take care of yourself and your children. The fact that you have a tire that has a hole in it could be an opportunity for you to demonstrate that you're able to figure out how to fix that and how to get to work and how to get to some of your services despite that barrier, which does not frankly seem like one that you would need to go all the way to the agency in order to ask for help with. So I just want to let you know that the perspective that's being offered here today, perhaps as Ms. Heiss observed as well, might need a little bit of adjusting for you. The agency is here to provide opportunities for you to improve your situation. They're not here to do it for you. And every time that we hear that you need help down to such a small, minute level, and that there are all of these additional barriers, it's difficult to understand. The big perspective here is that without housing, without employment, and without attention to the things that you need to tackle, like your mental health and parent education, I'm going to have to look at the success that your children are having in foster care and decide whether or not that's a permanent arrangement. So I can appreciate the advocacy here this morning, but I don't want you to get the wrong idea. These are opportunities. These are not an opportunity for you to present more challenges in order to have these people help you help yourself. So please keep that in mind moving forward. It's clear at this point that the children do have to remain where they are. That's a safe facility restrictive under the circumstances. We are still looking for employment, housing, attention to mental health needs, and parent education and demonstration of parenting skills to the extent that Ms. Rosas could take care of her children. And unfortunately, we don't have that today. Hopefully we'll have more progress in the next report period. We'll have our next review on Monday, January 13th, in conjunction with the review of progress that the father is hopefully going to be making January 13th at 10 o'clock in the morning, and we'll be back next. The order reflects all of the other things, including the approval of Ms. Heiss and her efforts, as well as the approval of those reasonable efforts. And unless there's any questions.